Good afternoon, everyone, and thank you so much for joining us today for this expert session on the draft Karnataka Rights of Person with Disabilities in Employment and Education Bill 2025, which is actually currently open for public feedback. So, this session is part of our effort to create awareness around this draft, especially since this is the first time that any state has come up with such a draft, and it could potentially become a model for other states to follow as well. For the discussion, our speaker for today is Deeksha Malik. Deeksha is a lawyer who works as a principal associate at Khaitan Co. In the employment, labor, and benefit practice. Her work spans employment law, workplace conduct, social security, and inclusion focused advisory. So she has worked extensively on diversity and inclusion, disability rights, and prevention of sexual harassment, and has contributed to key resources on the rights of people with disabilities and LGBTQ plus rights. She has also authored the book named Sex Based Harassment in the World of Work. Welcome, Diksha. We are really glad you could join us for the discussion. To help guide us today's conversation, we have our moderator, Shashank Pandey. And Shashank also is a lawyer and is the founder of Politics and Disability Forum. He has previously worked with VD Center for Legal Policy and served as a LAM Fellow. He was also recently selected for the Global Disability Leadership Academy 2025 from India. Delighted to have you here today as well, Shashank. Without further ado, over to you, Shashank.
Hi, thanks, Alexa. Thank you for the introduction. Thank you, Deeksha, and thank you to everyone who joined in this, especially in the winter season. And we hope to bring forward, points from the legislation, as Alexa mentioned. This is a unique sort of legislation because this is the first time that we have seen any state has put out bill for reservation in private sector for person with disabilities. I mean, the first thing is that it has put out a reservation private sector, and then the second layer is that it is for person with disabilities. So it sort of holds importance on both the fronts, that to what extent a state can provide for reservation within the private sector, because that's a disputed question across socioeconomic group. And the second is how much operational or how much success this bill can achieve when there is already union law at the which is enacted in 2016, which is called Rights of Person with Disabilities Act. So, for context of the audience, reservation for person with disabilities is there under RPWD Act, but the reservation is only for in public establishment. So, there is a definition of establishment under RPWD, which includes both private and public. But the reservation provision under RPWD address only public establishment. So that means only government institutions, both education and employment. In education, it's 5% reservation, irrespective of nature of disability. But in employment, it's 4%. But that 4% is also very specific to the identified disability. So unlike education reservation, employment reservation is not available to all kind of disability. So that's union law for your context. Now we'll go forward and try to deliberate upon the contents of this Karnataka draft bill. So I'll start, Deeksha, with your initial thoughts on the bill when you went through the contents of the bill, which is a very short bill, just 10 pages, around 30 odd sections. What were the initial thoughts when you saw the content of the bill, and especially you have worked at the firm, you must have worked with a lot of corporations and MNCs. So what is your perspective from that angle?
Thank you, Shashank, and thank you, Alaksha, everybody else, for arranging this. Very important bill, for sure. It's unfortunately not gaining a lot of traction, probably because of enforcement of labor codes, which is actually becoming the focal point of discussion amongst the private sector. So, which is why the attention that this bill would have otherwise gotten is not something that is currently getting, but definitely, we are working with some of the industry bodies in putting together proposals regarding, certain reforms to this bill. But initial reaction, I think, of course, from an affirmative action standpoint, a good initiative for sure. Intent is at the right place. However, of course, there are a lot of ambiguities around concepts, obligations of employers, and we'll touch upon these in greater detail. But definitely, in terms of the operational realities, I think this is slightly in deviation from what the on-ground realities are. So I think that's the general reaction that all of us have. And just to clarify, this is not the first time that Karnataka tried to introduce reservation for persons with disabilities in the private sector, contrary to what most people think. There is a central law which is called Industrial Employment Standing Orders Act, and every state comes up with rules under this particular law. Now, of course, this law has been repealed by Industrial Relations Board, but so far, by and large, this was the law that governed the terms and conditions of employment of in industrial establishments. And the Karnataka rules underwent amendment, where Karnataka government mentioned that every industrial establishment needs to provide at least 5% reservation for persons with benchmark disabilities as defined under Rights of Persons with Disabilities Act. So this reservation requirement was always there in Karnataka for establishments which are covered under ISO Act. Probably did not receive a lot of traction because on the one hand, Karnataka brought about this requirement under Industrial Employment Standing Orders Act, but at the same time, it exempted the entire IT sector from compliance with Industrial Employment Standing Orders Act. So, which is why a lot of companies didn't have to necessarily come up with this particular reservation, which they will now have to if this particular bill sees the light of day. So, I just wanted to clarify that this is not the first initiative, but definitely one which is overarching now. Because every establishment with 20 or more employees will now have to comply with this. So yeah, these are the broad observations, and of course, we'll take it forward from here.
Yeah, thanks for the clarification. I think that was important because those specific rules are something that we often miss the details. And you talked about the labor, sorry, the labor code that has come has been recently been implemented. So I want to take this point ahead that same with labor code that now the states, for example, Karnataka has also implemented what's called gig workers law. And now the new labor code also has a provision on gig workers. So there is a discussion on what will happen to that Karnataka law because it might conflict with the union law. Now, I want to take that point here also that if this bill becomes an act, this also addresses education and employment. Also, it goes far beyond what RPWD Act actually does, that it actually prescribes what with the reservation within the private sector. But do you think there is a there's a possibility of conflict that this bill might create with the union legislation? And if such conflict do occur in employment law, what is the usual recourse that is often taken, out of this to avoid such conflict?
Sure. So, see, at the end of the day, before we even come to the conclusion whether there is a conflict or not, how the conflict will be resolved. Before we come to that, we have to see whether there is a conflict or not, right? So, if there is a central law and a state law dealing with the same subject matter, first you see whether there is any possibility of both laws operating together, right? If there is a way we can harmonize the provisions and comply with both laws, and they can actually coexist, then the conclusion is that there is no conflict. It's only that when we comply with one law, we end up not complying with the other, is when a real conflict arises, and in which case we have the constitutional provision, Article 254, which clarifies that the central law will prevail in such kind of inconsistency. Now, coming to specifically the private sector, if you look at Rights of Persons with Disabilities Act, it never had such kind of reservation requirement for the private sector. It primarily used to mention that the private establishments need to come up with an equal opportunity policy for persons with disabilities. And if there are 20 or more employees, then this equal opportunity policy needs to be fairly detailed. It needs to mention what kind of assistive devices, what kind of infrastructure adjustments the organization is coming up with. There has to be a liaison officer that helps with recruitment of persons with disabilities, and sometimes special leave may also be given to persons with disabilities in case of any challenges that they have to encounter by virtue of the disability. So the primary obligation of a private sector entity under the central law used to be to come up with this particular policy, notify one official as a liaison officer, and that's about it. You register that policy with the State Commissioner for Persons with Disabilities, ensure that there is no discrimination as such, and that was about it. It was thanks to the Vikash Kumar judgment of the Supreme Court of India that the Supreme Court actually said that the obligation of reasonable accommodation, which is mentioned under Rights of Persons with Disabilities Act, also extends to private sector. If you look at just the central law, the only primary obligation is to develop this policy and have a liaison officer. But thanks to Supreme Court, even the obligation of reasonable accommodation now applies to the private sector. But again, the law fell short of uh, having an affirmative action plan for private sector. And that's where this particular state law steps in, which says that not only you prohibit, you prevent discrimination, but you also ensure that you are reserving certain posts for persons with disabilities. So, in that sense, at least for the private sector, Shashank, my view is that both laws can coexist. Yes, certain clarifications need to be provided for the state bill, but they can certainly coexist, and I don't think that there is a conflict per se. Of course, there are few concepts which are overlapping slightly because you have a concept of liaison officer under the central law, and now there is a concept of grievance redressal officer under the state bill. So, are these officials going to be the same, or whether these will be two different officials having two different purposes? One dealing with just how to provide amenities and ensure fair recruitment, the other one actually resolving issues being faced by persons with disabilities. Is that the difference? Or is it that the official can be one and the same? That overlap exists, but otherwise, I believe that there is no conflict per se.
Yeah, I think I want to bring another facet because of you mentioned the the redressal and liaison officer which exists in both the laws. This particular state law also provides for a body enforcement body, what the state is calling for implementation and ensuring that law is enforced. Now we also have something called State Commissioner for Persons with Disabilities, as you mentioned. That is a sort of a redressal body constituted under the RPWD Act. Now the I mean my prima facie reading of it is like it appears that there might be a conflict, and especially if I'm a corporate or if I'm a establishment, private establishment who has to adhere to both the laws, and if there is a violation or a sort of alleged violation of any provision, and the person goes to both the bodies. Now, how do I sort of cope with that particular thing? Is there a this particular enforcement body? Is there a possibility that this might create a conflict and enhanced sort of compliance for these private establishment and also confusion to that extent?
Sure. So, Shashank, definitely both laws are coming up with their own bodies. We don't even know it's going to be the same or a different body altogether. That clarity, of course, is not there at this point. But certainly, as far as the private sector is concerned, Shashank, we could take the argument probably that there is again no conflict for the reason that if you look at the mandate of the government under Rights of Persons with Disabilities Act vis-a-vis the private sector, it used to be limited to registering the equal opportunity policy for persons with disabilities. You wouldn't find amongst the powers of a state commissioner a right to reinstate somebody in the services, for instance, if they have been dismissed from service by a private sector employer. Why that's the case? Because the central law never dealt with that aspect. It only required a private establishment to come up with an equal opportunity policy and notify a liaison officer. So your grievance under the central law as a private sector employee was only limited to not having this kind of a policy in place or a liaison officer in place. That's the limited grievance you could bring up before authorities under Rights of Persons with Disabilities Act. in this particular legislation, the state one, if and when it is brought into force, a person who is aggrieved by the actions of a private employer can actually go ahead, demand not just reasonable accommodation, but even temporary reinstatement in services, which is a very dangerous remedy that this particular law is talking about, because reinstatement in services is always a final remedy. It cannot be an interim remedy. And that's a very settled proposition of law. But this law somehow is introducing the concept of interim relief being reinstatement in services. So it's coming up with these brand new remedies which were not there under Rights of Persons with Disabilities Act. So in that sense, while there could be multiple authorities, it seems that their jurisdiction appears to be different, or their powers appear to be different between central and state law.
Yeah. So I'll come to the point of the establishment that are covered, because like this particular act also goes ahead and provides specifically that establishment is the private that they are addressing, and which is unique in that particular law because this only deals with incidentally private establishment, unlike the union law. And in this particular law, they have also provided timeline. So for clarity of the audience, the law, if and when it's passed, the law won't immediately apply to all the private establishment. It has a sort of tiered approach to the implementation, wherein the first year it will be only corporation with more than 250 employees, then it will be another, and then in the third year it will roll out across across MNCs. Now, one of the thing that I wanted to sort of ask you was that this sort of the position or the 5% will apply to the total cadre of the the employee sanction strength of that particular office, and 5% will be determined on that. Now we are also having a concept of independent consultants, part-time consultant, and now moving after COVID, we are also moving towards remote working setup. Now, a company might argue that the staff that they have is not technically based in Karnataka because they are working remotely. Is there a possibility that these might sort of arguments might come in now from private sector in case they want to avoid such mandate? Is there a possibility, or is there a sort of some clarity from law angle on how these assessments are made?
Let's divide this question into two parts. Let's talk about employees and then independent contractors, which are not on the payroll of an establishment. So I'll address the second part first. Independent contractors, contract workers, and so on are not supposed to be counted into the strength of an establishment, because the idea is that the law is focusing on the posts which a particular establishment is coming up with. Independent contractors and contract workers are, by definition, expected to be mere service providers, not people who are occupying sanctioned posts in a particular establishment, right? That's the fundamental concept between an employee and an independent contractor. So, unless the law expressly states that the strength will cover contract workers also. For example, if you look at Apprentices Act, it says that you need to engage 2.5% of the total strength of the workforce as apprentices. You need to have those, student trainees engaged by the private sector. Now, that law very clearly mentioned that strength includes contract workers as well. So, unless the law gives you that clarity, the assumption should be that the strength term, approved strength as it has been used under the definition of sanctioned post, that should be limited to only the employees. So, that is one clarification. The other is about remote working point. Very apt question, Shashank. I think companies obviously cannot, escape from their obligation by simply stating that, certain of their employees are working remotely. These kind of scenarios, we apply a legal concept called situs of employment or place of employment. An employee's geographical location could differ depending on where they are actually working from. But if their legal place of employment is Karnataka, they will continue to be governed by this particular law. How do you determine whether somebody's legal place of employment is Karnataka or not? There are several factors that courts have developed. For instance, is the employee expected to report to the office which is there in Karnataka? Are the supervisors of that particular employee based out of the Karnataka office? Are the wages being disbursed from the Karnataka office, and so on and so forth. So there are a lot of factors that you will look into to determine whether, even if somebody is working remotely, their place of employment is still the Karnataka office of that particular establishment. If that is being established, then definitely there is no way a company can escape out of that obligation.
Thanks. I think that sort of gives a lot of clarity in terms of the principle that you mentioned, because that was one of the apprehensions that we had of how and if the companies can claim sort of that difference, especially if they have multiple uh, sort of offices across India, which is the case with any private establishment having 250 employees. One of the things that actually the definition clause, mentioned among all the things that it mentions that it will apply to all the establishment above 20, but it also mentions that it won't apply to individual sort of businesses, and it also says that the application to consultant and franchise units will be determined as per the rules issued under the act. I want to have an understanding, what does these franchise units mean when it comes to application of such laws?
So, Shashank, your guess is as good as mine. Very
Yeah.
frankly, we have never seen such kind of exclusions from any particular labor legislation.
Yeah.
So, even we don't know what kind of establishments they are talking about. It appears that they're trying to say that if you have, business partners, uh, franchisee partners, or contractors who are providing services to you, your partners might not get covered under this particular legislation unless the state rules prescribe any specific conditions around their coverage. But the service recipient here, the entity that is utilizing the services of a franchisee, partner or a contractor, that entity definitely will be covered. But the point is, how do you define, franchisee partner or even a contractor? For example, I could be an IT company which requires some specialized software developers for which I approach TCS. Now, in this particular arrangement, TCS becomes a contractor. Are you then trying to tell me that TCS will not be covered under this legislation unless the government prescribes rules around their coverage? They are an entity in themselves as well. They are also employing a regular workforce. So the requirement around reservation should apply to them also. So just like while they are contractors, they are also employers of certain people. So then what is the point of excluding contractors from the definition? It's unclear, Shashank. I mean, what
Correct.
I'm trying to say is that an entity can be an employer for some people, can be a business partner or a contractor for somebody as well. Then how do you reconcile? So many entities will then get excluded from coverage.
Right. I think, yeah, this is something that I was also struggling with to understand why they have provided such mandate and why they are waiting for the rules when almost everything that they have provided or could have provided are mentioned in the act, including for the sort of consultation period. But before going on to that point, I would like to ask you from your experience of having engaged with these private enterprises on the understanding of reasonable accommodation, because last year we had Rajiv Raturi, and one of the significant facets among many things that the judgment spoke of was actually this differentiation that it created between accessibility and reasonable accommodation. Now, that differentiation is something that we who are working in disability law had for a long time, but general public or maybe the employer doesn't have it. So now this act is also very interesting in that sense because it goes far beyond what is prescribed as a definition in the union law, and it adds what qualifies as reasonable accommodation. For example, relaxation in working hours, digital accessibility, accessibility of your workspace, and it goes one step beyond to create it a legal right by saying that whenever a person asks for reasonable accommodation, you have to address it within 7 days, and the entire incident should be wrapped up within 30 days. My understanding is that it sort of creates legal right through this law. They are creating a legal right of reasonable accommodation, which was anyways there. They are just making it a very specific. Now, I want to understand, does employer and even the employees who are asking for reasonable accommodation, do they have an understanding of what the reasonable accommodation is vis-a-vis accessibility, because accessibility is universal, reasonable accommodation is individualistic. That's the jurisprudence understanding that we have. But do corporates also have this understanding, or do they also just make a, the minimum assessment of their entire workforce and develop physical attributes of accessibility and few attributes of digital accessibility and say that yes, we have provided reasonable accommodation? So just wanted to know ki, how does private enterprises have taken up this till now?
Shashank, very frankly speaking, private establishments never took the concept of reasonable accommodation seriously. If you look at the law itself, Rights of Persons with Disabilities Act, it never very clearly mentioned that private establishments are also required to provide reasonable accommodation. Like I said, it was only a purposive interpretation of the Supreme Court through which this requirement was also extended to private sector. And very honestly speaking, even that judgment was never implemented in practice by the private sector. So, all in all, so far, we have never seen instances where companies have actually reviewed individual cases of disability, entertained such requests, reviewed those, taken medical opinion from people if required, and then opine on a particular case. That has never happened in the private sector. Like you rightly said, if at all certain facilities were provided, those were largely around.
Laksha, I think we lost Deeksha.
Yes.
Okay. I think she dropped from the meeting. Let's wait.
Yes.
I think she'll join again.
Yeah. That's it.
Meanwhile, if people have question, maybe you can put it down in your comments, and at the end of it, we can take up those. And also, we'll have a time for Q&A, so you can also raise your hands then and ask them. So, meanwhile, if you have any queries, you can put down in the chat.
Hello.
Yes.
Yes.
Hear you.
Hi, Shashank. Hi, everyone. So sorry, I think there was some issue with my Zoom application, so I had to join from my phone. Am I audible now?
Yes, yes, you are.
Okay. Can you please let me know till what point you were able to listen to me?
I think you were making a point that these, unless and until we had a purposive clarity from the Supreme Court with reference to the differentiation, the
Yeah.
private players were not very keen on adopting the practice.
Exactly. And just continuing on that point, I think the subtle nuance that you brought out, Shashank, that reasonable accommodation is individualistic in nature. I think uh, private establishments don't have that nuance. In their view, the moment they provide a rampway for a wheelchair user, they are actually giving reasonable accommodation. Or if their website is accessible, let's say it has voice assistance, for somebody who has a vision impairment, they believe that that's what is reasonable accommodation without realizing that it's really one step ahead. That while of course you make your infrastructure accessible, you still need to provide customized adjustments for somebody's need. I think that nuance was never there. And it's going to take a while, Shashank, to bring about that understanding within private establishments, which is why I believe that in addition to having a law like this, the government also needs to adopt sensitization measures for employers, right? Without giving that particular understanding to private sector, I'm not too sure how they are going to achieve compliance. So, how do you review a request? In certain cases, can you extend the timeline, perhaps because you yourself cannot appreciate the technicalities of a disability? You might require an expert opinion to first understand what the disability is about, and then perhaps understand what kind of adjustments are needed. So sometimes technical view is also needed, but if you look at the timelines, they're quite stringent, Shashank. So then in that case, how can organizations comply? Are there any technical experts they can approach to get an understanding on these subjects? That support system from the government currently is not there. So I think it's going to take a while for establishments to appreciate what all these obligations might entail for them.
Correct. Thanks. I think those were the points. Even I thought the private establishment will argue that they don't have a clarity, and the a point attached to it is that the law itself provides a sort of an escape route for corporation or establishment by saying that corporations can exclude themselves or take an exemption from this mandate if the reasonable accommodation creates undue hardship. Now, in the
Yeah.
operation of union law RPWD, we have a similar sort of setup for government also, wherein they say that if it's not financially feasible or economic aspect, we have seen that this is the argument, and this sort of the whether disability fits in into the mold of what you prescribe as being able, it has been used by government to create a blanket exemption for PWDs from certain job roles. Now, one of the very famous case is ongoing, which is the exclusion of person with disabilities from Indian Police Service under UPSC and similar
Yes.
railway police services. Those, so there is a blanket ban for person with disabilities from these. Army is also creating a blanket ban, but Army is a separate institution, so sort of few people have claimed that it's justified. But for Indian Police Service, there are a lot of administrative services as well, wherein they can be fit in. Now, this undue hardship is something which I fear can again be used by corporations to argue that person with disabilities are not suitable for this particular job role. And maybe if a corporation is having a very niche, having sort of niche exercise or a business practice, they might claim that the entire business doesn't allow for hiring a person with disabilities. Do you see this this possibility being there when you interpret undue hardship?
Absolutely, Shashank. I think if you look at it, that's probably the only breathing room that private employers have right now to avoid any sort of immediate obligations on themselves. But I think if and again, a lot depends on how you also interpret sanctioned post or approved strength. If the idea is that approved strength of the establishment, this particular term talks about your entire workforce. It is not approved strength in a particular category or role. Then it's going to be very difficult for companies to take this exemption, right? If it's 5% of the total workforce covering all sorts of roles in the organization, then for them to establish that it's an undue hardship might be more difficult because, as you said, Shashank, I might, for instance, be a private security agency company where I am providing perhaps private security services to my clients, right? And because I'm deploying security guards, uh, of course there is there are certain kinds of persons I cannot employ. But again, like any other organization, I would have an IT support team, I would have an accounts team, I would have an admin team as well, right? So for them to establish that none of these roles can accommodate a person with disability, um, it's a very tough proposition to make if the interpretation is that 5% is about the total workforce and not 5% per category of workforce. So we'll have to see, first of all, how government also is interpreting this. And if it's not limited to a category, then of course, it just seems more difficult for establishments to, uh, you know, successfully claim that exemption.
Thanks. I think this categorization and differentiation is something that you're looking that they might provide clarity when they notify the rules. I think
Yeah,
related to it will be a question, and these are all questions inspired from how we have seen operationalization of RPWD for like now almost 10 years or 9 years. Is the question of promotion, because that is something that this act is also silent about. There may be hiring, as you said, of person with disabilities, but the hiring might be there at the lower hierarchy, and there is, if there is no sort of category wise nomenclature or differentiation adopted within the act, the chances are that this promotion will also the reservation promotion will also not be there. That's my understanding of how I read the law, because there is no sort of, I couldn't find how they will monitor the promotion aspect, because they have put it that the 5% shall be eligible to the total hiring that is happening.
correct.
So do you think that there is something that can be used to claim that, yeah, I mean, it does apply to promotion as well?
So Shashank, of course, in terms of affirmative action, there is nothing, as you rightly mentioned. The only protection somebody has is that once they enter into the system, they cannot be deprived of promotion by virtue of their disability. So that kind of obligation is still there. It's not just there under this law. Even if you look at Industrial Disputes Act, which is now replaced by Industrial Relations Code, there is a concept of unfair labor practice, which also covers discriminating people for reasons other than merit. So, reading this law along with those other central provisions, once I'm employed as a person with disability, you cannot just disregard me from promotional opportunities solely because of my disability. So, organizations will need to have objective grounds to deprive me of that. But definitely, in terms of affirmative plan, there is nothing specifically dealing with promotions.
Got it. I'll come to the last point, and then we'll have maybe others also who might have questions, which
Yeah.
is that they have provided a sort of a statutory mandate for a consultation, which was something that I've seen for the first time in any law, that they provided for a consultation before issuing any rules or amendment to the rules, which they have to come up as mentioned in the act, if they decide to take the law forward. Now, from the private establishment, I mean, we have spoken of multiple points and what are the clarity that they would be seeking. But when the government is now going forward with the consultation before constituting the rules, what were the points that you think shall be taken into cognizance for such consultation, apart from not just putting, just doing consultation for checking the statutory mandate which is there in the law, but also coming up with a law which can be adhered, because that was a problem, or that is a problem with RPWD Act, that a lot of corporations still don't have this equal opportunity policy, because they still claim that it's discretionary and not mandatory unless interpreted by Supreme Court that it's mandatory. The claim or the sort of a fear is that those arguments will also follow in this particular law if the consultation doesn't take their interest or industry groups and industry consortiums into confidence before issuing it. So just your sort of thoughts on that part.
Sure. So one point definitely on equal opportunity policy. Also, I think Supreme Court has now made it absolutely clear that uh, developing an equal opportunity policy is mandatory. Unfortunately, that's the only part where Supreme Court, is stepping in and addressing the ambiguity. If I mean, I feel that there's no ambiguity, but to people who thought that this is optional for them, I think Supreme Court made that clear. Only interesting point was that if you look at how the law is drafted, it says that your policy should contain these XYZ particulars, like what assistive devices you're providing, what infrastructural support you have. What if a company develops an equal opportunity policy, mentions that it is going to have necessary infrastructure adjustments and so on, but then is not actually providing any assistive devices or or an accessible workplace? So, is the requirement under the central law only that a policy needs to be developed? Or is it that whatever you are mentioning in the policy, you have to actually achieve that? You need to actually have assisted devices or accessible infrastructure. So that part remains ambiguous, and primarily because of the wording of the law as well. Um, and I believe that's how, many employers are preparing a very bare bones sort of policy these days. They are mentioning that they treat everyone equally, they don't discriminate. The only criterion is merit, and that's it. And they probably will notify one official as liaison officer if somebody has any questions vis-a-vis the amenities and so on. They can approach the liaison officer. That's the short abridged version of equal opportunity policies employers are coming up with, just to fulfill the mandate of having an equal opportunity policy. They are not mentioning what facilities they are providing because there simply aren't any in reality, right? So, this is the kind of leeway that organizations were currently using. The state law, as in when it comes into force, it's not giving that kind of ambiguity also. But of course there are a lot of concepts which are not clear, Shashank, and the rules cannot clarify the loopholes in the substantive provisions themselves, right? Rules can only talk about areas where the government has themselves mentioned that these aspects will be covered under rules. For example, how will contractors be covered? That will be prescribed in the rules. So the rules are only going to act upon those particular items which are being identified to be covered under rules. But rules will not give you clarity on, for example, what does approved strength mean? Or how reasonable accommodation needs to be interpreted. So that clarity needs to happen through necessary modifications in the bill itself. That can't happen through rules. So
Correct.
that's one clarification I wanted to bring, that rules will be more about the procedural aspects. It won't clarify the substantive obligations, because for that you need to revise the bill itself. Yeah.
Thanks. Yeah, I think one thing that I want to add on the equal opportunity policy, because this is something that I went through the BRSR declaration by the top listed entities,
Mm.
and a lot of their declaration actually covers equal opportunity policy. But when you open their equal opportunity policy, or what they call it, equal opportunity policy, it's a general statement which sort of covers everything. It's
Absolutely.
a lot of companies actually call it a DEI policy. Some
Exactly.
call it non-discrimination policy. So that is what they are feeding into, and that's a compliance that they have to submit to SEBI. So that's the status of what we are struggling with is called equal opportunity policy, and let's see what happens in this particular. And as you rightly said that rules cannot define or move beyond what is prescribed in the parent law, one of the principle
Absolutely.
of delegated legislation. So I'll open the floor for the audience, and just for context, the law also covers education, but we didn't cover education part because employment is what we were focusing upon in this session. But the bill also has provisions for education, wherein 10% will be reserved for institutions. But that is something for a later date. But I invite people who may have queries to maybe raise their hand or put it into the chat box. Alexa, can you moderate that part?
Yeah, sure. So we had a few questions here. One of the questions said, this was one for you, Shashank, actually. If there are any insight on how this bill came into being, um, will be good to know so that similar advocacy push can happen in other state as well. Yeah,
I
any
think
question?
if Diksha has any inputs on this, because
Yes.
my understanding is this bill came out of blue. To be honest, we were not expecting this bill, or we were not aware that this bill will come. We were aware that the discussion is ongoing to have something like this in Tamil Nadu. That is one state that we were actually hoping that it will be bringing forward. But Karnataka is something that I wasn't aware of. So that's my understanding. But yeah, Diksha, did you or were you aware that something like this was in pipeline?
So nothing in the public domain, of course, Shashank, but because, as I mentioned, Karnataka had already provided for 5% reservation as part of the model standing orders that they had implemented. they realized that for some reason, no one is paying heed to the model standing orders. And in any case, they had themselves exempted IT companies from the purview of that requirement, which is why the applicability was always very limited. And there was discussion amongst the government, circles that there should be an overarching law to deal with these aspects. And that's how you saw this particular bill transpiring. But I think it was, out of the blue. We were not expecting this to happen. It was just some observations from certain government officials that they are not able to see companies complying with the model standing order requirement, and something more needs to be done to make to place emphasis on this requirement. That was the only discussion that we heard of. So yes, we don't know if other states are also going to replicate it. Karnataka has been coming up with very sweeping requirements. You saw reservation for persons with disabilities through this bill. Just a few months back, we had the not just few months back. In fact, in November itself, they also enforced a government order which requires all organizations to provide menstrual leave, which is now under challenge before the court. So a lot is happening in Karnataka, but not sure how it's going to be replicated in other states.
Thank
Thank you, Diksha. Thank you for such insight. Yeah, one of the attendant did say ki, can we also speak about education? However, as Shashank has already clarified, this time we are speaking on the employment part. I think that is it. If anyone would like to just, you can unmute yourself and ask any questions if you have.
Shashank, can I go ahead? This is Raja here from Vishesh.
Yes, please, sir. Yes.
Deeksha, Shashank, I mean, thanks first of all for this webinar, and it's very insightful and informative. I have two questions. One is, we have seen, recently this, for example, the SEBI order. By the time it was, it was the digital accessibility, as you know, and it created a lot of awareness and push among the regulated entities to go towards disability and digital accessibility. This was passed in the order came in July, but it came, we can see in December, it's come down to a very watered down version, where the initial version was, you appoint an auditor, submit your gap analysis report, fix the gaps, and then, get back to us on compliance. Now it's a watered down version saying, okay, on March 26, you just have to let us know whether you are compliant or not, and some remarks there. So obviously there is a lot of lobby that is working in diluting what is required. So from here, in this case also, I mean, as a person who's strongly advocating for employment, and we see employment as a litmus test of inclusion at Vishesh, what can be done to ensure? I mean, I don't know what is the next step in terms of getting this bill into a law. What can be done as a group to see, there is no dilution? First question. The second is, from the implementation standpoint, even if, okay, we see this becomes a bill, is there anything else that is required to be done, like, government orders to be issued, office memorandums to be issued to ensure there is implementation of the provisions of the law? And the third is a clarification. Sorry, one more question. Third is about the 5% requirement. Is it against the headcount of the organization? If it is against headcount, it's going to be a massive, gap to fill. Or is it about vacancies that is notified? I saw that it says 5% of the vacancies, it can be carried over for 3 years, something of that sort. So some clarification on this will help. So three questions here, Shashank.
Sure.
Yeah.
Deeksha, you want to take the second and the third? Maybe I can address the first.
Sure. I'll just clarify on the last one first. I think it's the language which is used under the bill is 5% of all sanction posts. And if you look at the definition of sanction posts as well, um, from a private sector's perspective, it's talking about the total approved strength of the establishment, right? So if you look at that, it appears, and again, this is just a broad reading of the bill, and of course something where we are seeking clarity through our proposals as well. This could be talking about the total strength, the total headcount of the employees that a particular establishment has, and 5% of that is what the bill is expecting. Again, people are asking whether it's about 5% in each category. For example, I have, let's say, a finance department, or maybe the division could be on managerial, non-managerial lines also. That within the managerial cadre, I have to maintain 5%, and then another 5% for non-managerial. So a lot of questions are coming in at this point in time. Just looking at the literal language, it appears that they're talking about the total strength of the particular establishment, not, of course, counting in the non-employee workforce like contract workers and consultants.
Yeah, and the second part on how the bill will be implemented, like what are the next legal steps for the implementation?
Yeah. So I think, of course, right now it's in a consultative phase, and very frankly speaking, because government is also dealing with labor code enforcement, challenges to menstrual leave provisions, there's a lot that state government has on its plate at this point. So we don't know how they are prioritizing this particular bill, how soon it's going to get implemented. But definitely, we are aware that there are a lot of industry bodies like IFKI, etc., CII. They are all putting together their own recommendations. We are, in fact, collaborating with some of these industry bodies to put together our proposals as well. We expect the state government to hold meetings with at least the notable industry bodies like FICCI and all, and maybe take their inputs on priority because they represent such a large number of employers. And of course, based on that, we might expect the final bill to come out to be tabled. It will first be approved by the cabinet and then tabled before the state legislature. And then, of course, the normal process of passing any bill, we'll have to see that coming through. So there are a lot of legal steps which will transpire before any effective challenge can be done on the bill, on the law itself. At this point in time, one cannot approach, the court to bring about clarity if the state government is not acting on our proposals. So there is no recourse there. We've seen that in Haryana, for example, when the government tried to bring reservation for local candidates in the private sector. A lot of people realized that government is not listening to certain proposals, and they started approaching Punjab and Haryana High Court. And the court simply said that, look, it's in a bill stage. Until and unless the law is enforced, we cannot look at the challenges vis-a-vis the provisions of that particular legislative instrument. So people had to wait till the law was actually brought into force, and that's when you saw the High Court entertaining any challenge to the law and even ultimately declaring it unconstitutional. So there's a long journey ahead. Let's see how it goes forward.
Yeah, thanks. I think on the first point, so that you asked on how the sector can do what the person with disabilities or the organization of person with disabilities can do, is what Deeksha mentioned was the representation that is being sent from a corporate side to the government is exactly what the sector needs to do and exactly what sort of we are also trying to do. That we want to present a more informed and legally sound submission to the government and argue that your so that it doesn't appear that we are accepting it or denying it on a blanket assumption, but have to provide them a corrective measures on how the bill can be made better. And this cannot be from a one-sided perspective, as in it cannot be just discussion among the OPDs or the person with disabilities and submitting, but you also have to engage with private players because there is a lot of stigma from their end. So there has to be a collaboration and engagement with FICCI and CII and all ASOCAM, all these industries bodies, to present your sort of understanding that these mandates are required, so that you also have a clarity and we are also not discriminated against. I think so. This informed sort of engagement with corporate body and government has to happen. Only then, otherwise there will be like two extreme spectrums of submissions to the government, and again government will go on the side on which they have a better understanding and which they see is more persuasive. So in that sense is what should be the next sort of ideal step.
Thank you. Thank you, Shashank. Shashank, Deeksha, you mentioned 5% of sanctioned posts, and so you said it excludes contractors. So is that right?
Yeah, that's correct.
Consultants and contractors. So companies can just say we are going to only appoint consultants and find a way around.
No, of course that cannot happen because look, there are of course a lot of guidelines around how you can engage consultants or independent contractors, as we call it. You need to still fulfill those tests around contract of service versus contract for service, right? If you are engaging somebody for a sustained duration in core integral activities of your organization, they are subjected to your supervision and control, subjected to performance and conduct related rules, etc. Um, if all facets are akin to that of an employer-employee relationship, then merely calling somebody as a consultant cannot really give that status to them, right? So at the end of the day, those people will still be considered as the employees of the organization. So, and I don't think any organization, just to be able to avoid this obligation, they will end up categorizing everybody as consultant. That cannot happen because even from an income tax standpoint, the way you make deductions from somebody's payment, all of that will be impacted by that kind of categorization. So I don't see any company making such a drastic measure just to be able to skip this law. But as Shashank was also mentioning, there is this one particular aspect about undue hardship. Chances are that establishments might try to invoke that to say that they are not able to achieve, reasonable accommodation in certain cases. Those kind of arguments can still be made, but I don't think somebody is going to categorize their people as consultants just to avoid this liability or obligation, rather.
And sorry, one more question. Is it to keep the positions open or to fill? We have seen the obligation is only to notify that these are positions that are kept open and reserved.
Absolutely.
But never, because they'll say we don't get qualified and eligible candidates and they go unfulfilled. So is the onus on them to also to show, to the evidence that yes, they have made their best effort, but they couldn't get the right candidates, etc.
You're right. I think the obligation is to reserve, not necessarily have 5% of your strength as persons with disabilities at all times. I don't think that kind of obligation exists. It's primarily about reserving and and trying your best to ensure that when you are opening positions, you are catering to different categories of persons with disabilities. I think there's a language to that effect also under the bill, that there needs to be very reasonable distribution even amongst persons with disabilities. I cannot just say that I'll only focus on one particular category of persons with disabilities. So it's a lot there. But again, I don't think that the requirement or the expectation of the government is that at all times you need to have 5% of your workforce as persons with disabilities, and which is where the carryover aspect also comes into the picture, that if you're not, despite your best efforts, able to employ people despite reserving certain posts, you can actually carry over those positions subject to certain limits.
Thank you, Deeksha. Thanks.
And all very valid points, by the way. We are, in fact, putting this in our recommendations also to have this clarity from the government itself. What's their intent? Is it just to reserve, which they were trying to do under model standing orders also? So, what is changing then? So, we are trying to seek that clarity from government as well.
Thank you, Raja. I don't see any other questions for now.
Yeah.
Maybe we can.
I think there is no other question. So I think just one thing which Rajaswara mentioned and Diksha clarified. Apart from this clarification which is sought from the government, there is also, if whatever they clarify, the hiring process by a lot of these private establishment also has to change, because apart from other things, now they also have to ask for disability as a characteristics. You have to identify whether you are a person with disability, and you also might have to submit documents to prove you're a person with disability. So one thing which I didn't discuss in this session, which is another very controversial thing, is that the law doesn't mention UDID. It only mentions disability certificate as issued by state authority. Now, UDID has been rolled out as a universal identity proof for disability and is being heavily rolled out by central government, wherein you can avail benefits through UDID only. That is the extent that a few schemes have went to. But the law doesn't mention UDID. So how does that sort of is going to operationalize when the persons are only being issued UDID now? And you can obviously download a digital certificate from the portal, but as a hard copy are only allocated UDID. That's what I've seen. That both a personal and a professional experience. So that is another aspect actually, that a lot of these corporates will ask for this certification, and if there is no clarity whether they will be accepting UDID just because there is no mention of UDID in the statute, can they deny those that identity proof as well? So that's another clarification that is needed. And yeah, Diksha, there's one point, because sort of we both come from law background. I also wanted to know, do you see law firms actually doing the 5% categorization? Because I was very curious to know, because very few person with disabilities actually go into a law background and pursue law firm domain, because of the sort of, again, the nature of work, if you can say it. So do you see that a lot of law firms are actually based out of these Karnataka? Do you think that they now will move towards having operationalized this mandate if and when the law comes into force?
Very difficult question, Shashank. Honestly, I don't have an input on that. I have not seen law firms taking this bill seriously as yet. Apart from, of course, employment lawyers like ourselves who are helping our clients to put forth these proposals to the government. But I don't think law firms are realizing that they will also not, be, out of the system. They will have to comply at some point. Um, of course, it won't apply to the legal positions, Shashank, because we are all retainers.
Yeah.
We don't have an employer-employee relationship, and I think that's a key difference between how the law is worded right now. It's not trying to cover independent contractors, whereas we are quote unquote retainers and not supposed to be employees. So I think that distinction is there, but certainly legal law firms also have admin support, IT support, a lot of people on their payroll as well. So at least to that extent, they will have to comply.
Correct.
But I don't think that realization has come through yet.
Thanks. I think thanks for the clarification. I think there were a lot of points that even I wasn't aware of, and hopefully people have got more clarity. And there is a lot of clarity that we are also actually seeking from government, because when we see the operation of RPWD Act in that context, and then operation of employment and labor laws, there is a lot of ambiguity even seeing it from the private sector, because it's better that they have a clarity. Otherwise, the only natural instinct is to evade rather than conform if there is a lack of clarity. So that was the purpose of this sort of session, to sort of debrief and do a threadbare analysis of just the employment component. As I said, education is something that we haven't touched also. So I would request people to go and read on the education part as well. It's a very short law. It's a draft, and the submission has to happen before 21st. So whatever submission that you can send, the instruction is in the concept note that we circulated for the session. So yeah, that is all from my side. Alexa, you can take that forward. And thank you, Diksha. Thank you for agreeing to do this.
No
Yes.
worries at all. Thank you so much.
Yes, thank you so much, Diksha, for sharing such thoughtful insights on this draft, particularly from the lens of employment here, touching upon these key areas, the affirmative action, the interaction between the state or the central act, and also the need for a government-led sensitization if they would want the private establishment to compile. Thank you so much. And yes, thank you, Shashank, for guiding this discussion so smoothly and bringing in some really important perspective through this conversation. Lastly, thank you everyone who was able to join us for this insightful session. We hope today's discussion was useful and gave you a better clarity about the draft law. Like Shashank mentioned, just a reminder that the draft is open for public feedback till the 21st December, and you can easily share your feedback through the WhatsApp chatbot, which I have posted in the comment section. Thank you all and have a wonderful day ahead.